And welcome to In Your Corner once again. John Scholes, Sivan, Tumarkin, and James Fireman are here. In Your Corner is all about disability law and fighting the little guy. Well, not being with the little guy, fighting the big guy. We always make it about size. I don't know why that always happens every show. But it's about disability, and it's about fighting that insurance company, making sure you get the rights that you're owed, the money you are owed, and that's why we're here to protect you over the next 30 minutes. Lots of stuff to cover today. Anytime you want to reach out, 1-833 In Your Corner, help at inyourcorner.ca, and we made it simple. The website is also inyourcorner.ca. Lots of stuff to get through today, guys. Savannah, I know you want to start with basically kind of a week that was sort of thing, right?
That's right, John. And you know, this week I was going to talk about a success story that we had. We generally start the show showing people that they can fight insurance companies, they can stand up to them, they can't force insurers, to pay them what they owe if they understand where the weaknesses are for the insurance company. But you know what? Instead of talking about that success, I'm going to talk about something that happened this week. One of our associates spoke with a lady who actually went to a different lawyer before she heard about us. And she's been on disability for quite a while, since 2017. And she went to that lawyer because she was denied long-term disability by her insurance company. And I have a letter here, and I'm not going to show to the camera the letter or the letterhead. Right. But let me tell you a little bit about this lady. She stopped working in March of 2017 as a result of post-traumatic stress disorder, depression, anxiety, a whole variety of things. And there were some traumatic things that happened to her in the past that have triggered her inability to work. And she has a whole slew of doctors that are in fact saying that she's unable to work. They continue to say that since 2017. So what does she do? She does the correct thing. She consults a lawyer. Unfortunately, I don't think it was the correct lawyer in this case, because what this lawyer proceeded to do is he proceeded to appeal the long-term disability denial. But wait, John, not only did the appeal go nowhere, and now that lawyer is telling her, now we are now almost 2 years after she was first denied, not only is the lawyer telling her now she has to start a legal claim, which is what James and I always say, that you have to do as soon as you are denied LTD or cut off LTD, but for that appeal, I haven't run this by you, James, that lawyer actually charged her almost $9,000. That is insane. That is absolutely insane. Any lawyer that I know that knows long-term disability law and knows how to fight insurance companies, and in our case, we've worked for insurance companies in the past, will tell you that if they believe in your case, you are not going to pay a dime until that case is resolved with the insurance company. Now, we're going to be able to help this lady, but it's unfortunate that she's had to go through this nightmare. Not only has she been denied for almost 2 years now, no money coming in, but she's actually been forced to pay this lawyer for a completely useless step, which is to appeal that denial. And here's the irony. The reality is that had she contacted us back then, her case would most likely have resolved at this point. Yeah.
$9,000 seems completely inappropriate regardless of whether you should be charging or not.
As far as I'm concerned, even a cent is too much for this.
Yeah, no, there's no reason that this lawyer should have been advising his client to appeal. You know, when you appeal, what you're doing is you're allowing the insurance company to keep control of the process. They have all the cards as long as they control the process. It makes no sense. As soon as you bring a legal claim, you remove control from the insurance company and you start to level the playing field. And that's what it's all about. They have a huge advantage until you take the control away from them.
Now, in this particular case, would it be fair to say that because it was stress, anxiety, PTSD, I mean, these things, have we all often said on this show, they don't show up on an x-ray. So insurance companies are like, denial. I can't see it. It's not on a slip of paper, right? That's pretty common, no?
It's very, very common. We see a lot of people with psychological, psychiatric, emotional types of illnesses and disabilities get denied, rejected outright by insurance companies. And that's despite the fact that a lot of these individuals not only have family doctors supporting them, but psychologists, psychiatrists, social workers, a whole slew of people who are saying to the insurance company, pay this person, they are disabled, they cannot work. Insurance companies, again, we've said it before, we'll say it again, for them it's a numbers game. If they deny 10 claims, they are hoping that at the very least 9 out of those 10 are going to walk away. That people will think that it's a David and Goliath thing. You know, you can't take on Goliath.
Yep.
The other element of that is the people who are suffering from mental health issues are the ones who are most susceptible to that kind of tactic, the ones who are least likely going to be prepared to fight back because they're suffering from anxiety or depression or other issues which make it psychologically very difficult for them to deal with the stress of an insurance company questioning whether they're really disabled. And so the insurance companies do this, in my view, quite purposely because they know that this is a vulnerable population that isn't likely to fight back.
InYourCorner.ca is the website you want to use to check out anything having to do with this show. We also do a radio show also called In Your Corner. And you've also guested on and been on Employment Hour with your partner, Lior. From that radio show, we get a lot of calls, not only about employment law, but because of the crossover between the two types of law, we get phone calls as well about disability and injury law. So I want to get to a phone call from the Employment Hour and have you guys comment on it.
I am on disability right now due to medical reasons, and my insurance people are putting me through all kinds of rigmarole. And I also found out from a coworker that my job was replaced. I'm 60 years of age. I don't know if there is anything to come back to. I am scheduled for some surgery, but what my insurance people are trying to do is get me back there before then, which I know could be a hindrance, but I am struggling to do my best to, whatever they want me to do, I'm doing that.
Not a fan of rigmarole. Never a fan.
No, not a fan. And again, remember, John, I mean, people oftentimes get hit from both sides, the insurance company and the employer. And of course, we have lawyers on our team that deal both with employment law and disability law. And that's very important to understand, because if you go to two separate lawyers in two separate offices, they don't necessarily talk to each other. And that's a problem, because employment law and disability law, there's going to be an interplay between them. And if you go to two separate lawyers who don't talk, you may end up with less money in your pocket because of the interplay of the benefits and the severance that you may get. Now, with this lady, here's something that's very important for people to understand. If you are not ready to go back to work, if your doctors are telling you that you are not ready, you still have to do certain treatments, you have to take time off and remain off work, you should follow your doctor's advice. You should not be forced to go back to work. But what insurance companies will do, John, is they'll tell you, if you don't do what we tell you, we will cut you off. So in a way, it's a bullying tactic. But they have no right to do that, and there is a way to fight that. There is a way to hit back. Don't do what they are telling you if it's contrary to your doctor's advice, because at the end of the day, you're going to get worse. Your doctors are not lying to you. And the insurance company doesn't have your interest at heart. Your insurance company, their only interest is to save themselves money. And the way they do that is by getting you off claim. And one of the ways to do that is to try and force you back. But no one's putting a gun to your head, and you should not do that. And if you are in that position, give us a call and we will help you.
Yeah, one of the things I tell all of my clients is that even though you've started this legal claim and you're involved in the process, that doesn't mean that that should dictate what you do in your life. You have to make decisions that are right for you. And first and foremost, you have to make sure that you're making decisions that are right for your health and your well-being. And that comes from your doctor and your healthcare professionals. And those are the people that you listen to when you're making decisions that involve your health, such as going back to work. So whatever your insurance company is saying, you have to make the best decision for your own health, and you have to proceed that way. And if they cut you off, then you have an option. We start a legal claim, and we take the control away from them.
Now, listening to your doctor, of course, is number one. They have the trump card in all this. But there can be, and there is times where the insurance company will send you to one of their doctors, right? You have to go.
Yes, you have to go to one of their doctors. It's usually a provision in the policy that states that if they want you to be assessed by one of their own, not necessarily a doctor, by the way, it could be a medical specialist or it could be a consultant, which oftentimes means it's not an MD, not a doctor. Right. But here's the thing, if they are sending you to one of their people, then it's a red flag, because it means to me that they're questioning whether or not your doctors are being accurate, they're questioning whether or not what you're telling them is the truth, and they are priming your case for the eventuality that they'll be able to cut you off. Because as soon as they get that report from their assessor that says, no, we think this person is ready to go back to work, or perhaps can do other type of work, they will use that often to cut you off. So as soon as that happens, again, as soon as you are told you're going to be cut off, don't wait until you're cut off. As soon as you are told you're going to be cut off, they usually give you a heads up. that's when you contact us immediately. You don't wait, because trust me, they will cut you off.
You know,
Sorry, I was just going to say, to be clear, what we're talking about here is when your insurance company sends you to one of their doctors for an assessment. It's very different than if they try and make you go see a different treatment provider. That you don't have to do.
Okay.
But if they want you to be assessed by one of their doctors, yes, you have to comply.
We mentioned doctors. We're going to keep on that theme. In fact, the top 3 things disabled individuals should never ask their doctor to do. That is coming up, and lots more. In Your Corner continues. Stick around. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to inyourcorner.ca. Lots more stuff to go through here. Chances are, if you're on disability, you've seen a doctor, you have a team of doctors. What we're going to tell you, the top 3 things disabled individuals should never ask their doctor to do. You want to reach out anytime, by the way. It is help@inyourcorner.ca and 1-833-IN-YOUR-CORNER. So this is important stuff. A lot of people don't realize this going into this, right?
That's right.
First one, never ask your doctor to write a report containing inaccurate, false information.
Yeah, that puts your doctor in a really, really difficult position. They're there to provide you with health care, and they're not used or expecting to be asked to do something that they might feel, and frankly is, quite inappropriate. And that jeopardizes your relationship with your doctor, and especially if you're talking about your family doctor, your primary health care provider. That's a relationship that you really don't want to disrupt. You don't want to ask them to do things that are going to make them uncomfortable, and then find yourself in a position with a doctor that doesn't want to treat you anymore, or who isn't going to be supportive of you when you need them down the road. And the other thing is, it can really backfire, because if your doctor is acting ethically as they should, and they're going to refuse to do that, they may well put that in their notes, and that's going to be available to anybody who looks at your doctor's clinical notes and records down the road. So it's just a bad idea. You don't want to be asking your doctor to say something that isn't in fact the case.
And I think, is it fair to say that if they end up doing that, even if it's a little tiny thing, the insurance company will use that against you if they discover it is falsified, right?
Absolutely. They'll use anything they can against you whenever they can.
Yeah. Top 3 things disabled individuals should never ask their doctors to do. Number 2 on the list, never ask your doctor to minimize or downplay your disability. Why, and why would you do that?
Well, here's the thing. When James and I are giving advice to clients, we tell them, tell the truth. It's something that seems self-evident, but just like you have some people who tend to exaggerate, you have the opposite type of people who tend to do the exact opposite. I remember a lady that I was representing a few years back who suffered a spinal injury, and she was walking with a cane. She was the sole provider for her family, a really, really strong lady, and she was back at work within, I think, a couple of weeks. And she was in tremendous pain. I came to her home, I visited her, I spoke with her husband, her kids, and what I remember is when I was looking through her doctor's records that she would underreport a lot of the pain. She's not a complainer.
Don't be a hero.
Don't be a hero, because the problem is, if you are a hero, the insurance company is going to say, fantastic, that's great, that's excellent. That means you can go back to work, when in fact you can't. So just like you should not exaggerate symptoms, be very careful when you underreport symptoms to your doctor, because your doctor, if they're doing what they're supposed to, they'll record everything. And if you tell them that you have no pain, you have no limitations, when in fact you do, that will be in their records, and that will be used against you by the insurance company. I can guarantee you that.
You think it's something that would go back even to talking to an adjuster on the phone, say, how are you today? Oh, I'm pretty good. I don't feel too bad today. I'm not in any pain.
Happens all the time, even more innocuously than that. Just, hey, how you doing? Okay. Client says he feels okay.
Oh.
It's as
That
simple
little
as
word,
that.
eh?
You know, we
Wow.
say this all the time, but you have to remember that your insurance adjuster isn't your friend. It doesn't mean that you should be rude or impolite, but remember when you're speaking with them that you have to have your guard up and be careful in what you say because it's going to be recorded. And if you say anything that can be used against you, it will be used against you.
Again, 1-833 in your corner, inyourcorner.ca. We're talking the top 3 things disabled individuals should never ask their doctor to do. The last one is never ask your doctor to write that you're ready to go back to work if the truth is you're not.
Yeah, this is a big one, and I see this more frequently than you might think. And it happens for reasons that are understandable. People are in very difficult financial position, and even if they're getting disability, it may well be the case that it's not enough because if you're getting disability, it's still going to only be usually about 2/3 of what your salary is. And if you're already on a very tight budget, the difference might just be too much for you to cover. And at a certain point, you feel like financially you have to get back to work. And so I've seen people ask their doctors to say that they're ready to go back to work when they're not, and that's incredibly dangerous because if you try to go back to work and your doctor has said, yeah, she's ready to go back to work when you're really not, and you go and you give it your best shot, but you're just not able to do it, they're going to use that doctor's opinion against you down the road, and they're going to say, your doctor says you're ready to go back to work, obviously you're just not trying hard enough or you don't want to be there, which is the exact opposite of what the case is. And so they will use that against you. It's incredibly dangerous. The only time you want your doctor to write that you're ready to go back to work is when you're ready to go back to work. When your doctor feels you're ready and when you feel you're ready. That's when.
Let me play devil's advocate on that one for a sec, Sivan. What if you're trying to go back to work because there might be some financial impact? You feel like you have to. Your doctor doesn't think you are. You said, no, I'm going to go back to work. Doesn't that look good as far as you're trying to mitigate the problem with your insurance company? Shouldn't you have a light shining on you, like what a good soldier this guy is? He's trying to mitigate, or
You should. But here's the thing: insurance companies are not interested in the truth. They're interested in saving money because by saving money, they're making money. Yeah. And so, and again, remember, I mean, we used to work for insurance companies. I remember looking at claims, looking at people's medical records, and myself, on behalf of my client, the insurance company, trying to figure out how can I target the claimant's credibility. That was my job. That's what insurance companies do. That's what their lawyers do. And the fact that we did that in the past allows us now to, help our clients avoid those pitfalls. So, yeah, technically you are correct, John. But that's assuming that we are all pursuing the truth. Insurance companies are not. Now, here's what I think you can do if, in fact, you want to go back to work and you want to try. If you want your doctor to write that note, and assuming your doctor is comfortable with writing a note that says that you should try to go back to work, I have no problem seeing a note where the doctor says the individual is asking to try to go back to work.
Okay.
I think it's appropriate for them to try to go back to work because at that point, the doctor has not pegged themselves into a hole. They haven't said the person is ready to go back. They've said they are ready to try.
Give it a shot.
Exactly. Yeah. And so if that's not successful, then you can say it looks good on the individual and the doctor did not commit to the proposition that this person is in fact ready.
Also, in that scenario, often what you'll see is the doctor will say, yes, this person wants to try to go back to work. I'm okay with that as a doctor. I'm okay with that as long as they don't start off working more than X number of hours per day, X days per week, that they avoid lifting over a certain weight, what have you. Whatever limitations are appropriate for the individual and that the doctor feels are necessary, they'll put that on whatever letter or form they're filling out for their patient in order to help them return to work on a provisionary basis. And that way, if it doesn't work out, it doesn't look as though the doctor has said you can go back to work. The doctor's saying we can give it a shot. We don't know.
I'm sure you guys, in the time you spent with insurance companies on the other side, you must have looked at cases going, man, this guy's trying to go back to work. This guy has no business trying to go back to work. But you can't say that, obviously. You're working for the insurance company.
No, if the insurance company's saying, great, this has just got a whole lot easier for us.
Right, but you guys are going, you shouldn't be doing that even though you knew better, right? Yeah.
Well, anyway.
That's a different story, isn't it?
It is.
Inyourcorner.ca is the website, 1-833 In Your Corner. Taking a short break. We will get to the impact of a pre-existing condition on a disability claim. That is on the way. Don't go anywhere. Lots more In Your Corner is coming up.
You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And right back at it, In Your Corner, inyourcorner.ca, the website, and help at inyourcorner.ca. You want to send over an email. Another resource for you is called mydisabilityquestions.com. There's a place for you to ask a question. Chances are it's been asked and answered in depth, but if not, you can leave it there. Sivan, James, one of the team will get to it and answer it for you. Again, mydisabilityquestions.com. Lead by example. Here's one for you. My friend has been on LTD for over 2 years after being sexually harassed by her boss. Her adjuster was great and understanding, but her new male adjuster says that she should not have been approved in the first place because this is a work issue exclusively. Can they just change their mind like that?
John, this question is packed. It's packed with a lot of things. So let me see if I can unpack it, and I'm sure James will chime in. The first thing that stands out to me is that she's been on LTD for over 2 years. And that indicates to me that clearly for that period of time, the insurance company's official position has been that, in fact, they agree she is disabled from working not only in her own job,
any job,
but in any job for which she's suited for by training, education, or experience. That's that 2-year test. To get LTD beyond 2 years, you have to show that not only can you now do your job, but any job. Now, the second thing that stands to me here, is really stark here, is that the new adjuster is a male adjuster. We don't know enough about the history here, but that potentially has, in my mind at least, certain ramifications. And I say that because of the new environment that we are in, the Me Too movement, et cetera, et cetera. I'm wondering what the dynamic is here with the initial adjuster. And frankly, if we started a legal claim, we would actually get the insurance company's file. So we would see a lot of the communications that occurred from the beginning of the adjudication of this claim between the adjuster, the initial adjuster, presumably that's a female adjuster, and this individual. And then see what happened with the male adjuster. So there could be a dimension there, and in my mind, at least, there is a possibility here of, if in fact there is bad faith in terms of the conduct of the new adjuster, that could open them up not only to a legal claim for the actual LTD benefits, if they cut her off, but also to extra contractual damages, meaning are they doing now something that is more than just cutting her off? Are they actually doing something that is perhaps touches on the whole issue of sexual violence, and again, the Me Too movement, et cetera, et cetera. Right. Go ahead.
I was just going to say, getting back to this question, what the question asks at the end is, can they just change their mind?
Right.
And unfortunately, the simple answer is yes. They can just change their mind. They can just decide like that, with seemingly no particular reason, to just cut off your benefits. They can do that, and they do that all the time. The question is really what can be done about it if they do just change their mind. And the simple answer is we start a legal claim. Because as long as they have control of the process, it's an unfair process for you. When you start a legal claim, that changes everything. Now, all of a sudden, the playing field's been leveled out. And we can take a look at the file and see what they've done, see the things that they've done that may have been unfair or inappropriate. Until we have that, what they're doing is essentially hidden from everyone. It's secret. You don't know what they are doing in order to come to their decision. But as soon as you start the legal claim, we get all that. We're able to figure out exactly what they've done. What was their process for coming to that particular decision? And was it inappropriate? And oftentimes it is.
And I know we mention this all the time in the show, and one of the brilliant offshoots of that is once you guys start a legal claim, all the contact now filters through you.
Yes.
The person in question no longer has that anxiety.
No.
That
as soon as we get involved, we are the ones dealing with the insurance company, with their adjusters, with their lawyers. The individual now is behind us. We are that wall between them and the insurance company, and that's across the board. There's no exception to that. And I just want to add something to something that James said. One of the questions here, other than can they just do that, is, sorry, not question, but a comment, is that there's an indication that this whole issue here, the new adjuster is saying that what's happened is that it's a situational circumstance, meaning that she can't work because of her work environment, meaning that if she was placed in a different work environment, she would be okay. And I don't know about you, James, but it seems to me that if she was approved for over 2 years for LTD, clearly there is some documentation from whoever's treating her that says that it's above and beyond just that workplace. Clearly, there's probably some PTSD, there's anxiety, depression, whatever else. And so it's important as well when an insurance company tells you, no, this is just a work issue. That's not necessarily the case. It's possible that something that started from work, whether it's bullying or harassment or whatever it is, generalized to something a lot bigger than that, such that if you were now to try and work elsewhere, you wouldn't be able to work. So it's very important to understand the distinction.
That's obviously the case, because the insurance company, despite their desire to cut off benefits as soon as possible, has agreed to pay beyond the 2-year mark for a certain period of time, meaning they have accepted that this person has a disability that prevents her from returning to any occupation. For some period of time, they've accepted that. So I don't really see how they can then, after the fact, go back and construct an argument that, no, actually your disability is really just about your own environment, because if that were the case, they would have cut her off, not just at the 2-year mark, well before that. Well before
the beginning, maybe.
Yeah.
Yeah.
I want to get to an email. I did mention a pre-existing condition portion of the show. I want to get to that now. It comes from Christina. Again, it is help@inyourcorner.ca. Christina writes in, says, what happens if a person is disabled due to several illnesses, but one of them is a pre-existing condition? Can the insurance company deny the claim just because of one of the causes is that pre-existing condition?
Well, again,
do.
my first comment is, can they? Sure. They can do whatever they want to do, but will it be justified? And if challenged, will it hold up? That's really what the question is. So pre-existing conditions are interesting, and they can vary from policy to policy. But generally speaking, a pre-existing condition won't be excluded as long as you weren't actively receiving treatment for it in a certain period of time before you first became insured. Not before you first went on disability, but before you first became insured, and you were able to work during that time. So in other words, you might have a long-standing heart issue, for example, but if you weren't actively receiving treatment over, the 3 months before or whatever it's defined by the policy, and you were able to work during that time, it's usually not going to be excluded. But let's say we're talking about a condition that is excluded in that particular case. Just because you have one disability that happens to be excluded, if you do have other disabilities, as Christina is suggesting here, then the question really becomes, if we ignore the excluded disability, do the other disabilities on their own, are they sufficient to prevent this person from, in the first 2 years, returning to their own occupation or afterwards any occupation? And if the non-excluded disabilities are sufficient in and of themselves, then you have a valid claim. And if not, you don't. That's the way it works.
Because I know you've fought this battle with insurance companies, with people who, for instance, are diabetic and they have problems with limbs and they end up getting removed or other things. And you have to kind of navigate it that way, right?
Yeah, you do. And James explained it really well. The intricacies, and he hasn't even delved into the law.
Right.
But this is something that I just want to highlight, that insurance companies will use absolutely any reason to cut you off if they think that you will be convinced that you have no case. And oftentimes, in fact, most times, you have to, or you should consult with a disability lawyer, and that's what we do because we understand the law. We understand the way judges have ruled on these issues. Insurance companies understand that as soon as we get involved and we call them on these reasons or excuses for why they're cutting people off, they back off. They have to back off because the result is that they're going to end up having to pay on a judge's order.
Right.
So they understand that, and it's going to be a long battle for them, and they don't want to do that. Remember, any time that we start a legal claim and they have to defend that claim, they are now bleeding money. They have to defend the case. They have to pay a lawyer. They have to pay an adjuster to deal with this. They're not interested. They're assuming that you will simply walk away. As soon as you don't, that's when they come to the table and try and engage you and try and get a settlement.
Good for another show. You want to reach out and contact James Sivan, a member of the team, anytime. Very simple. It is 1-833 In Your Corner. Email, as we just read from, help@inyourcorner.ca, and the website, inyourcorner.ca as well. Till next time, this has been In Your Corner. We'll catch you again.